Guys, welcome to this video. If you're interested in an overview of how the automated dispute process works when you do a dispute through the credit bureaus, then I think you'll find this video interesting. So we're going to talk about ACDV, eOscar, Metro 2, what's a CRA, what's a furnisher, who in the world is a CDIA, and we'll just do this in an overview format, but I hope that this will be helpful to you. My name is John Watts. I'm a consumer protection lawyer, and for many years I've been helping consumers with their credit report errors by using primarily the FCRA, Fair Credit Reporting Act. So let's kind of look at the terms or the players here. So number one, we have the CRAs. Okay, sometimes we call these the credit bureaus, the credit reporting agencies. More formal name would be a consumer reporting agency. And we have four big ones, but three are really big, and then the fourth one is kind of lagging behind, but we're going to mention them because they're involved in the CDIA and the Metro 2. So the big ones are Equifax, Experian, TransUnion, and then number four would be a Novus or Innovis, depending on how you want to pronounce it. Then we have the furnisher. So the CRAs collect our information and they'll publish it to people. Well, where do they get that information? Well, it's from the furnishers, sometimes called the data furnishers. So this would be like Capital One, Bank of America, Midland Funding, Portfolio Recovery. These are people who provide or furnish information to the credit bureaus. So you have the CRA and you have the furnisher, the data furnisher, and they provide data to the CRAs. And that's where your credit reports come from. Well, who or what is the CDIA? Well, that's the Consumer Data Industry Association. Now, that almost makes it sound like this would be some type of consumer advocacy group. They are not. Okay, absolutely not. This is made up really of those four credit bureaus that we talked about, Equifax, Experian, TransUnion, and Innovis. And they publish what we call the Metro 2 guide. Now, that's not the official name, but it's Metro 2, which we'll talk about that in just a second. So what is eOscar? And if you look on the screen, I'll try to get my cursor over here. You know, the E it would just be sort of electronic, okay? But the Oscar is going to stand for these words. So online solution for complete and accurate credit reporting. So think about that. This is something, it's an online portal, online system, if you will, and it's for complete, and it's not complete or accurate, it's complete and accurate reporting. So this is kind of the communication system between the CRAs and the furnishers. Okay, so you could think of it like, you know, it's a messaging system. I heard one guy from eOscar describe it. He's like, we're sort of like FedEx. You know, somebody hands us a package, we deliver it. So the credit bureau, the CRA, Consumer Reporting Agency, hands us a package related to a dispute. We take that to the furnisher. The furnisher gives us a response. We take that back to the CRA. At least that's how they like to describe themselves. Well, what's an ACDV? Well, that stands for Automated Consumer Dispute Verification. So that's the information. If we go back to here's the CRA, here's the furnisher, and eOscar is kind of the communication network between them for disputes. The credit bureau, the CRA, turns the dispute into an ACDV and it sends it through eOscar to the furnisher. And then the furnisher responds through eOscar to the CRA. Well, what's Metro 2? Well, that's just a standardized way of compiling the data. So these four credit bureaus, again, Equifax, Experian, TransUnion, and Innovis, they don't want to get 10,000 furnishers giving them information in all different formats. So they say, look, here's the standard sort of uniform way that you must report to us. And the stated purpose in Metro 2 is to comply with the FCRA, Fair Credit Reporting Act, to have complete and accurate credit reporting. So not incomplete credit reporting, not inaccurate credit reporting, but complete and accurate credit reporting. So that's the purpose of Metro 2, is to guide you in, as a furnisher, how do we report this? You know, what do we do if there's a bankruptcy and then there's this? Or how do we report collection accounts? What about the date of first delete? All these things. It's a couple hundred pages. And Metro 2 put out by the CDIA, which if you sort of follow this here are the CRAs. They make up this group, which comes up with this Metro 2, which tells the furnishers how to furnish. So we got the furnishers over here, how to furnish to the bureaus. And then this E-Oscar is kind of the communication for disputes, and those disputes are turned into an ACDV. I know it's kind of a lot of information, but I just want you to kind of see, at least to get a quick understanding of kind of the players and what these terms mean. So what is the FCRA? So we're putting aside all this Metro 2, CDIA, all that stuff. What does the FCRA require? Well, there's two ways to dispute under the FCRA. One is you go directly to the furnisher. So you go to Capital One or Bank of America and you say, guys, there's a problem. You have inaccurate credit reporting. And they do have obligations there. Unfortunately, you can't sue for that. They can violate the law and say, we're proud to violate the law. You can't touch them in a suit over that. So we're going to ignore that for now. We're going to talk about what in the industry is called an indirect dispute, which sounds sort of weird, but what that means is you go to the CRA, the Consumer Reporting Agency, Equifax, Experian, TransUnion, Innovis. Now again, there's dozens of different ones, but whoever qualifies as a CRA, you go to them. I have a dispute. Here's who I am. Here's the account or accounts that I'm disputing. Here's why I'm disputing them. Then what happens? Well, they have liability or obligation under the section 1681I. You can remember this because I stands for investigation. You go to them, the CRA, and say, investigate something. I think there's an account on my credit report that's either incomplete or inaccurate. I want you to fix it or delete it. Well, 1681I is what tells the CRA what its obligation is. Now, if the CRAs are negligent, or even worse, you can sue them. If the furnishers are negligent, or even worse, you can sue them if you have gone directly to the CRA, who then will provide, in sort of the industry language, an indirect dispute to the furnisher. So you're not necessarily going directly to the furnisher, although you can, but you need to go through the credit bureau, the CRA. And then that puts liability on everybody if they do a negligent or even worse type of violation. So on the right-hand side of the screen, we've got CRA must respond within 30 days. Sometimes it can be 45 days. Now, what do they have to do? Unless they can just immediately fix it without going to the furnisher, or if there is no furnisher involved, like it's a public record. You know, they have a bankruptcy on there. You've never filed bankruptcy. Well, there is no furnisher. They're just supposed to go investigate by dealing with the court or LexisNexis or whoever they're doing, but they have an obligation to fix it. But putting aside something unusual where the Bureau says we don't even need to contact the furnisher, they have 5 business days to notify that furnisher. Now, the FCRA doesn't say here's exactly how you must notify them, but it just says you must notify within 5 business days. So you've got to tell the furnisher what's happening here. You know, what's the dispute about? Who's disputing? What's the account? What's the basis of it? Now, then the furnisher, when they're notified, however that happens through the CRA, they must investigate. And if it's incomplete information, it's inaccurate information, they must fix it or delete it. And they're supposed to review the information that comes from the CRA. Now, they might also hear directly from you, and then they may have their own documents. Now, some of them would argue with that last point. They would say, no, we can close our eyes to all of our records that prove that we're doing false credit reporting. We don't have to look at it. Most judges do not agree with that, okay? If you properly notify a CRA, you say, this is the account, this specifically is what is inaccurate or incomplete, then the furnisher is going to have to take whatever the CRA tells them, whatever you've told the furnisher, and I believe they have to look at their own information. I mean, if you're talking about payment history is all messed up, well, I don't think they can just close their eyes to their payment history on their computer, okay? And again, most judges would agree with that. Now, the CRA has to investigate as well. It's not enough just to notify the furnisher within 5 business days. They say it is. And they say all we have to do is just parrot back, just repeat back whatever the furnisher says. Almost all courts say, no, that's wrong. And if the furnisher or the bureau, the CRA, realizes, hey, this is inaccurate information, it's not accurate, it's incomplete, it's not complete information, then make it accurate, make it complete, or delete the account. Pretty simple. That's what they have to do. Now, let's look and see, how is that translated in this world of we've got ACDVs, we got eOscar, we got Metro 2, how does that work? So on the left-hand side, I've got, this is what the industry would tell you. So like CRA receives the dispute, they turn that dispute into an ACDV, okay? Usually they're picking one or maybe two codes from about 25, 26 codes, okay? It might be, it's not mine, it's been paid, it's fraud, whatever it might be. And then they transmit that through eOscar to the furnisher. And then the furnisher receives it through eOscar. And then they need to verify it as accurate. They need to modify it. They need to delete it or say we have to delete it because of fraud. And then transmit that back to the CRA through eOscar. So again, eOscar is kind of this pathway, or like a shuttle or something that goes from CRA to furnisher and back from the furnisher to the CRA. Now, let me tell you the real world here. That's what we have on the right-hand side. The CRAs try to have either no human involvement or the most limited human involvement. That's why they love for you to go online. They're begging you, go online, fill out a dispute form, you check the box. So see, over here where the CRA normally would have to have some employees or contractors take your letter and turn that into codes. Well, you do their work for them over here, and they limit you on the number of codes, okay, and the choices. And I mean, I very rarely have clients do an online dispute. I happen to just go through it because I wanted to see the process, and it's incredibly annoying how limited things are. You go, well, wait, this doesn't quite fit with what the error is. And so you're checking a box that really is not correct. And that's designed on purpose to limit your options. And then if you're trying to sue and they go, well, you checked this box and that's a little different than what you are complaining about now, you may lose your case. So I do not recommend online. If you do online, make sure you do a screen record, just like I'm doing right here. I'm recording my screen. And also, I would upload a letter, okay? Give them all the information that you possibly can. And when the CRA does have a human looking at it, usually it's a foreign worker and really a foreign contractor, okay? At the furnisher level, so remember, here's the CRA. They transmit through eOscar to the furnisher. Well, the furnisher is trying to have no involvement with humans or very, very limited involvement. So they can just immediately flip that back through eOscar to the CRA. So here's a couple of thoughts. And this is the third bullet point. If you send a long letter, if you have lots of documentation, if you have detailed explanations for what's wrong, they do not like that, okay? Because they're being paid on sort of a per dispute basis. Well, if that is a half a page, that's one thing. If it's 18 pages, they don't really get paid anymore for that. And so this is not something they're interested in. A lot of times they'll just ignore it, okay? Now, is that good or bad? Well, if you're trying to fix it, it's bad. It's also really, really bad for the CRA to ignore your letter and say, well, Judge, we only read the first page. Like, this thing was 5 pages long and they had 35 pages of attachments. We are not reading all that. Here's what I want you to think about. If, let's say there's a problem with your Capital One account and you dispute it and you give a very detailed explanation. Here's exactly what's wrong with this field and that field and this field and that field. And the excuse from Capital One and Equifax, Experian, TransUnion is, it's too long of a letter. We don't read it. Well, does that work when you don't pay your bill to Capital One and they hit you with a late fee and you're like, well, I didn't know there was a late fee. They're like, it's on page 3 of the term and conditions. And you're like, well, I can't read past page 1. That doesn't work. If we break our lease in an apartment And on page 7, it says, hey, you may be liable for 3 months rent. We can't go, well, I didn't make it to page 7. I can only read to page 1. No, that doesn't work. It certainly doesn't work for these massive multinational corporations. Okay. So I say, send them as long of letter as you need. Don't make it longer than you need to. But if you need 5 pages to explain everything, take 5 pages. I mean, we've sent dispute letters that have 30, 40 pages of attachments or enclosures with them. Hey, if they choose not to read it, that's on them, buddy. They got a big, big problem if they choose to do that and they get to the wrong result. So I have down here in the green, just to emphasize this, there are lots of mistakes made. And part of that is, think about it this way. Does the CRA make any money when you send a dispute letter? The answer is no. So it's not that they're just even, they don't make any money, but they don't lose. No, they lose money because they have to pay their contractors. They have to set up computer systems. They should set these things up where it would flag illogical things, okay? So like if it says on Equifax, which reports date of first delinquency, that your date of first delinquency was January 2018. And then the pay history for January 2018, it says you were current, never been late. Well, that's illogical. They ought to flag that. They don't want to spend money on that. Okay. All that does is cost them money, brings down their revenue, brings down their profit, brings down their net income. Okay. And so when you do a dispute, they don't care about it. I mean, they're just like, how do we do this as quickly as possible and keep moving on? And how can we avoid it even? That would be better to just like pretend we never got it, avoid it. If the consumer says, I got 5 accounts that are wrong, how about we just investigate 1? That'll save us, 5 times the money, right? We don't have to pay somebody to do 5 disputes. We just pay somebody for 1 dispute. And so they're always looking for ways to cut corners on this. And that's why there are so many mistakes that are made. So what do you do when there's an actual error? And I know I harp on this, but I probably talk to one person a day that reaches out to me, at least one person a day, who says, hey, I did this dispute. I think they did a lousy investigation. Can I sue? And my question is always, well, whatever it is that you're disputing about, is it being reported accurately or inaccurately? And usually they go, well, it doesn't matter because they did a lousy investigation. I go, no, actually, the only thing that matters is it accurate or inaccurate? That's the threshold, the foundation. If it is reporting accurately, I don't care if the credit bureau ignored you. There's really nothing you can do. Now, if it's inaccurate, now we look at the investigation. Was it negligent? Was it reckless? Was it willful? But we have to have that inaccuracy. So let's say you do that. You have a true inaccuracy on some of the data. You dispute it through the credit bureaus. You identify the account. You identify the errors. You identify what you want them to do. Correct it or delete it, and they just don't do it. Okay? What can you do? Well, let's start with the CRA. Remember, let me go back to the slide here. When we do a dispute through the CRA, it's section 1681I. Remember, I is for investigation. So we can sue under section 1681I for a negligent or wanton or willful or reckless, all the same thing, investigation. Now, there's also a provision called EB, which is maximum possible accuracy. And if they don't have reasonable procedures, I'm talking about the CRA, if they don't have reasonable procedures that they follow to assure maximum possible accuracy, then that can violate section EB. Now, sometimes there are some requirements about it must be published. In other words, a creditor or a user must have looked at your credit report to trigger that liability. That's true in some states, not in other states, but that's a possibility. And then the furnisher can be sued under section 1681 S2B. And I mentioned this before, but I can't tell you how many lawyers make this mistake. They file a lawsuit. I mean, it's a fabulous lawsuit. Under section 1681 S2A, they said, I went to Capital One, I went to Midland Funding, whoever it is, they did a lousy investigation, and I'm suing under that, and the court says, you have no right to sue under section 1681 S2A. And the lawyer's like, oh my goodness, I can't believe this. It's like pages and pages of text, and I can't use that. No, you can't. So 1681 S2B, that is where, again, we have CRA and the furnisher. We notify the CRA. It goes to the furnisher, ACDV through eOscar, and then the furnisher looks at that, sends the response back through eOscar to the CRA. Now, if the CRA did a lousy investigation, that's 1681I. If the furnisher did a lousy investigation, that's 1681 S2B. And then we may also can get the CRA under that section 1681 EB for maximum possible accuracy. So let's say you can sue any or all of these guys. What do you get? Well, in the green, have actual or compensatory damages. That could be economic or emotional. Here's the whole concept with this. This is where you were before the furnisher or the CRA violated the law. In other words, did a lousy investigation. After what they did, you drop down to here. Compensatory or actual damages, all the same thing. It's to bring you back to where you were. So what would that be in economic terms? Well, maybe they do a lousy investigation, and when you close on your house after that, you get a 5% interest rate instead of a 3% interest rate. Well, this is where you were, or where you should have been had they not done this wrong thing to you, and now you're dropped down to here because you're paying more money. What's the amount of money that you're paying extra? That would be the economic. And so we would look at that for a mortgage over 30 years. You know, maybe it's an extra $100, $200, $300 a month, whatever it is. Maybe you had to make a higher down payment. But on the monthly, we'd take that out over 30 years, add it up, and then reduce that to present value. In other words, what is, it's just a math question. $200 a month for the next 30 years, that's X number of dollars. And then what amount of money right now represents what would be 30 years of $200 extra dollars a month, okay? Well, emotional distress is, here's where I was before they broke the law. Here's where I am now. How much money will it take to bring me back up? Because I'm worrying about it. I'm upset about it. I'm angry about it. My stomach is churning about it. I'm nervous about it. All these things that at least where I practice, and certainly most places, will allow you to recover. These are real damages. Sometimes they're called emotional distress, sometimes mental anguish, all the same thing. Now, you also get attorney's fees and costs. And this is why, I'll just be very candid with you, it's very puzzling when a consumer says, hey, I have a great case and I'm filing it on my own. I mean, you can do that, but the credit bureaus, especially the credit bureaus, absolutely love that. Most of the bad law comes from pro se cases because the credit bureaus will, not that they are smarter than the person without a lawyer, not that they even have a good case, but they understand the procedural rules better. And so it'd be like playing in the Super Bowl and not realizing that you have 4 downs to make a first down. What if you think you only have 2 downs? And so at the end of, it's like 2nd down and 5 and you're like punting the ball. People are like, what are you doing? Well, you don't understand the rules. Same thing, particularly in federal court. And there's just no reason for that because your lawyer is going to be paid out of the settlement or paid by the bad guys that you sue. And the cost of litigation. So if you go in without a lawyer, not only do you not have the expertise, I presume you're getting a lawyer that knows what he or she is doing, okay? Doesn't really make sense to get one that doesn't know what they're doing. But if you get an experienced lawyer, they know what they're doing under the FCRA, you lose that benefit and you just made it a whole lot cheaper for the credit bureau or the furnisher. They don't have to pay attorney's fees unless you have an attorney. And if it's wanton, reckless, or willful, so here's negligence. That's being careless under the circumstance. That's not using reasonable care under the circumstances. Willfulness, wantonness, recklessness is a higher level, okay? And I'm not going to get into all the details of that. But when you show that, you can get statutory damages, okay, up to $1,000. More importantly, you can get punitive damages. That's to punish that credit bureau, punish that furnisher, and to send a message to all other furnishers or bureaus, CRAs, to say, Do not ever do this again. We're not talking about negligent conduct. We're talking about reckless or willful or wanton conduct. It just sends that message out. Your procedures are lousy. Your investigation techniques are terrible. And you knew it or should have known it. And now we're going to punish you above and beyond. Remember, actual damages are compensatory. Here's where you should have been. Here's where you are. It's to bring you back to you. Punitive is more than that. It's to punish them and to send this message so that when a credit bureau is going, should we let go of all these skilled investigators and hire people who don't know what they're doing because we could save money? Somebody's supposed to pipe up and go, excuse me, do you remember when Equifax got popped? Excuse me, do you remember when this furniture got hit with a $500,000 punitive damage or $1 million punitive damage? We don't want that. And they're like, oh, okay. That's the point of punitive damages. So I hope that this overview, not sure how long this video is taking, but anyway, thanks for sticking with me. I hope that it's been helpful to you. And if you like this type of video, feel free to subscribe. We try to put out a video every day. A lot of them have to do with debt collectors and credit reports. And if you have any comments, put those in. If you think somebody else might like this, feel free to share it with them. And I appreciate you guys watching, and I will catch you tomorrow. Have a great day. Bye-bye.